verify. It says that we are live. Yep, there we are. Okay, so what I'm going to do is make my video. All right, Jamie, take it away. I'm going to mute myself too, sorry.
Okay, hello everybody out there. I hope that everybody can hear me. This is the November 2020 Texas NORML monthly open meeting. Excited to have everybody here on Zoom or on Facebook. And of course, there's probably some folks that are watching this not live because it'll get posted to our Facebook channel as well. We, at Texas NORML, we always have an open monthly meeting. Used to do them live and in person. Of course, during COVID, we're doing them via Zoom now. My name is Jamie Spencer. I'm legal counsel for Texas NORML. I've done meetings before, but I should probably warn you, this is my first time leading a Zoom Texas NORML meeting. Luckily, I'm not fully in charge of how it's all being run on Facebook and Zoom, so I still expect that to go relatively smoothly. To give you a little bit of a preview of what we're going to be talking about tonight, first, our executive director, Jax Finkel, is going to come on and talk about yesterday's local and federal election results, specifically the ones that are of most interest to us in terms of eventually decriminalizing marijuana and other important election results. Of course, as everybody knows, there aren't results for everything at this point, and there won't be. I'm sure there'll be some talk about that as well. Then whenever I come on to do the meeting, since I am legal counsel for the Texas NORML board, usually we do a know your rights conversation. Since voting was yesterday, you know, we have about a 2-year cycle. For anybody that doesn't know, by the way, the Texas legislature meets for about 5 months, once every 2 years. It's going to be January through May-ish of next year, 2021. And during that time period, of course, we're very focused on what kind of legislation can get passed. The other, you know, approximately 1.5 years, we're working on voters' guides, letting people know what people's positions are, what their candidates' positions are. We have candidate forms for people to be able to make those decisions, as well as surveys that we send out, and making those answers from potential politicians available so our members can make informed decisions. That's a very important part of it. But so since yesterday was really voting, we've really moved on to the legislature portion of our year, so to speak, if you're not talking about calendar years. So mostly what we're going to be talking about tonight as lawyers, and I have 2 of the best here to help me along in that, is going to be about lobbying and those sorts of things. These are both criminal defense lawyers that have substantial experience in defending marijuana and other drug type cases. I'll talk a little bit more about that when I'm introducing them. Then also when we have lawyer night for our Texas NORML monthly meeting, we usually do a Q&A. Please throw any questions that you might have for a lawyer, whether it would be about lobbying or whether it would be about marijuana law, decriminalization, what the court process is like. I know that there are tons of questions still about the hemp rules that were passed 2 years ago and what the current status of that is. I'm sure there are tons of questions. When we used to do these, and someday again we will, live at the Flamingo Cantina, I would bring the lawyer yellow pads and pens and pass them around, and eventually those would make their way up on stage, and we would, the lawyers would take a stab at answering those questions. This time, if you would, please just put those questions in the chat. Also, we are going to have a t-shirt giveaway. It'll be for someone that asks a question in chat. We will do the giveaway near the end of the Q&A portion to let people get it in, but please get your questions in now. Nothing like a free shirt. Any rate, that is the plan for tonight in terms of tonight's meeting. Those questions, by the way, can come through the Zoom link if you're using that, or on Facebook. You can put your questions either way for those. Let's go ahead and start, however, where I said we were going to start, and that is with our executive director, Jax Finkel. She's going to tell us about the local and federal election results. Jax, take it away, please.
Awesome. Thank you, Jamie. So I have a few things to cover. As Jamie mentioned, there's a lot of election results that we are still waiting for at the federal level, a lot of close races. And if you were following election night here in Texas, you were probably very interested in the back and forth in the percentages for not only the presidential, but for many other races. And so I wanted to first start the conversation actually talking about some federal level changes that have happened. So as you probably know, there were several ballot initiatives in about 5 different states that had to do with either legalizing an adult market or legalizing medical cannabis. Now, just to set the stage, here in Texas, we do not have ballot initiatives, so we cannot go and collect signatures and bring it to the legislature and and bring an initiative to be on the ballot. That's not how it's here, unfortunately. What we have to do is we have to go through the legislature, the Texas House and the Senate, and then finally the governor. And typically it's a bill that you're looking at, that those are kind of the easiest things to pass through. But the closest thing to a ballot initiative we have is what's called a joint resolution. And what that is a legislator decides to author a joint resolution, which is an amendment to the Constitution. And that has to go through the same process as a bill, but it has to pass by super majorities as opposed to passing by a simple majority. And then after that, the joint resolution would go and be on the next ballot. So that following November, it would be on the ballot. And then it would come back to, assuming that it passes, it would come back to the legislature the following session for statutes and all that to be implemented. And then once that is enacted, it would go through the regulatory process. So it's actually like a 5-year process, you guys. It's really long. So I just wanted to set the stage for the different ways that it functions here in Texas. So talking about national news, there are, first of all, we'll start with Arizona. Prop 207 to legalize marijuana passed 60-40. So that's great news. I know Arizona NORML did a lot with collecting signatures there, and their late executive director who recently passed was really integral in making that work with all of the different organizations and chapters across the state. So very happy for Arizona. I think also they had some of the harshest laws, so it's nice to see that change, like such a dramatic change. Then we've got Montana. They had a constitutional initiative to limit or to create a market for adults over the age of 21, and that passed 58-42. Then New Jersey, they had what's called a public question to legalize marijuana, and it passed 67-33. Then we have South Dakota that had an amendment to legalize cannabis, and that was 51-46, so pretty close there. Is that exactly right? That doesn't add up to 100. I might have to double check that. And then we've got South Dakota to legalize medical cannabis. So South Dakota had adult and medical cannabis on the ballot, and that passed 70-30. And then in Mississippi, legal medical cannabis is now going to start the process of becoming available, and that passed 69-31. So once we're finished with tonight's meeting, I'm going to create a blog post with this video and a whole bunch of links to all of this information for you guys, because coming up in January, we will be holding a legislative policy workshop to get us all prepared for this session. So I want to make sure that we get prepared for that. Now, talking about locally, there's a lot happening at the federal level. Cornyn won against MJ Hagar. There were quite a few other races, but talking about the House and the Senate, which is the body that addresses our legislate or our bill needs and craft those things. We've got in the Senate, the Democrats picked up 1 seat. Roland Gutierrez won over Pete Flores. So that is an additional seat in the Senate for the Democrats. And it is of note that Roland Gutierrez actually plans to author an adult use bill. So you can look forward to that in the Senate and that conversation. And then in the House, There is going to be a change. Sarah Davis lost to Anna Johnson. So Anna Johnson will be a freshman now, Democrat out of that district. And then Mike Schofield is going to replace Gina. I'm not sure if I'm going to say this last name right. I'm sorry. Kalani. I'm pretty sure that's how you say it. And so Mike Schofield will be a freshman Republican from that district, with the same ratio of Democrats to Republicans in the House, and that continues a Republican majority. And to that, of course, we know to be an important conversation, and really sharing so that you can see where is legislators stand on cannabis issues, because they have addressed it before. So Jeannie Morris did not respond to our voters guide survey, but you can see her voting record there, that she voted yes for expanded compassionate use, legalizing hemp, and for penalty reduction. You can see that also Representative John Cyrier did the same. And then you can see that Chris Patty, he was a yes for medical, yes for hemp, but a no on penalty reduction. And then Chair Dade Phelan, he actually was co-authors on the medical bill and on the penalty reduction bill, and he voted to legalize hemp. So I think, out of all of those four options currently available of the Republicans, we can see who might arguably be the best option. Of course, there can be more people that may file from now until the first day of the legislative session. That is the day that the House will officially elect their speaker, and that's going to be January 12th of 2021. It is of note that we will also be hosting that legislative workshop in conjunction with Texans for Responsible Marijuana Policy on the 12th as well of January. And that will be giving us the most up-to-date information on how the pandemic will be affecting the hearings, et cetera. Right now, a lot of it's still up in the air, and interim charges are taking some written only testimony. So it's going to be interesting to see how that develops. So that is what I have, the general sum up of kind of the highlights for everything. I see that there are a couple questions down in the chat, but I am going to turn it back over to Jamie first and the lawyers so that they can have a little conversation. And then I think we're going to open up the floor for everybody to answer questions. So I'm going to go ahead and invite Jamie back up here, as well as Kristin.
Okay. Okay, and am I back on?
You are good to go.
Fantastic. And actually, I spotted a question, and I'm going to take it out of order because I just think that based on, Jax, what you were just talking about, right now is the right time to go ahead and address this question. From Teresa, how do we get the ballot initiative changed in Texas? So I actually had a little portion that I was going to speak about ballot initiatives. Jax has already done it some. This is something that comes up again and again. If you look at the history of decriminalization and legalization of marijuana over the last couple of decades and those efforts in the United States, the most successful ones, the ones that have been quickest, have indeed almost always started with some form of ballot initiative. And what Jax was talking about is that Texas does not have that legal mechanism. Citizens in Texas, I don't know, I'm to some extent an expert on Texas law, but certainly not California law. But for example, in California, they have some sort of a rule or a law that says, if some certain percentage or certain number, minimum number of people all sign something, that you can get a ballot initiative on. So in theory, this is something that was talked about in the distant past when there was less clamor nationwide, less popular support for marijuana decriminalization itself. There are organizations that attempt to, that are single issue organizations. Well, actually, I shouldn't say, I know there's one that is trying to get ballot initiatives to be a thing, not just for marijuana, but for anything in Texas, to give citizens the rights to do that. I would say, although I'm not necessarily authorized to speak for all of Texas NORML by any means, that I think that the majority opinion right now would be that given the current mood, given the fact that 83% conservatively of Texans want either some form of decriminalization, some form of legalization, some form of medical, or some combination of those, since we're really talking about an overwhelmingly popular issue, we're working on it directly. But that's why we're talking about lobbying tonight. We're talking about lobbying specifically because we are not talking about, the paid activity by professionals that go and lobby on behalf of organizations or corporations or businesses and those sorts of things. We're talking about your right just to go down and be able to talk to your legislator later. And so in the past, for example, in 2019, Texas NORML had 5 different lobby days where people came in from all over the state. There was a veterans lobby day, there was a patients lobby day, there was a seniors lobby day, there was a medical professionals day, which was a little bit, it was great. It was doctors and nurses basically telling legislators about why it was that they thought that they should be able to have this option with their patients as well. And then there was an everyone day. Obviously, there's a lot of overlap in what I was just talking about. Patients can be seniors, veterans can often be patients, those sorts of things. But there is that, we call it the marijuana policy lobby day. It's there for everybody. So we absolutely encourage you to try to make some of those. It's a little uncertain what that's going to be, how lobbying will look this year in the time of COVID. But at any rate, we are okay. So any other questions, please keep putting them in there. We will get to them later. I wanted to address that one first before introducing our first speaker, Kristin Etter. Kristin has been a lawyer for approximately 20 years. It might be more than that, but it's around that time period. She spent a couple of years being an assistant federal public defender. And let me tell you something, if you want to really learn your chops as a criminal defense lawyer, there is a reason for the phrase, don't make a federal case out of it. If you're just out of law school and you really want to learn about criminal law, going and working for the Federal Public Defender's Office will do you a world of good. And it's done Kristin a world of good. She was there for several years. She then moved to Austin, joined a firm here, Sumter and Gonzalez, where she's been for, I'm sure it's more than 15 years now. Well respected in both the state and federal bars here locally. Very happy to have her come and talk to us today about lobbying and those sorts of things, and also any sort of criminal defense or marijuana things she wants to talk about as well. So let me pass it over to my friend and colleague, Kristin Etter. Thank you.
Thank you, Jamie. And in fact, my colleague, Carroll, we have prepared a joint, actually Worth, and we're going to kind of go through. I think it might make more sense for your viewers if we...
Let's do Worth.
Okay, because we have a joint presentation that we want to share.
Makes sense.
Okay.
Makes sense. So Worth has been with Sumter and Gonzalez as well for several years now, and he's actually going to start the presentation. I appreciate you being here as well, Worth. Go ahead.
Thanks, Jamie. And I'm going to share a screen and with y'all, and my apologies ahead of time. If my internet connection becomes unstable, or if mine or Kristin's toddlers run in. So I appreciate everybody bearing with us. All righty. Go back to the beginning if we can. All righty, Kristin, can you see that okay?
Yes, Jamie, I hope your viewers can see that as well. So.
Okay, wonderful. So, we wanted to start out today, and I know that Jack's touched a little bit on this, but, given that at least I was glued to the little teeny tiny phone screen for most of the night last night, I figured we'd talk a little bit about how the Electoral College is playing out. I know we looked a lot at that map and continue to check it throughout the day. And, usually it's Kristin and I, we're talking a lot about red states and blue states and those kind of things. But what was extremely interesting to us is the green states as they've changed across the country. Isn't that right, Kristin?
Right. So this is a picture of, this takes into account the recent legislative changes that Jax was talking about. And I think that the photo is very helpful to all of the people that might want to help try to make some changes here in Texas, because if you can see, obviously the photo kind of speaks for itself, but we are really in a whole sea of green now. It used to be, you know, one state here and there, and the overwhelming majority now supports either adult or medicinal marijuana. And we really got to get Texas and these other states to join in. I know there's a question also that we'll get to at the end about what can we do in terms of hoping for federal changes, but we'll get through that after we talk a little bit more about the maps.
So we wanted to break it down into really three issues that Jamie, or three topic areas that Jamie addressed earlier. And it's really all about advocacy, advocating for the people, where we'll talk about different issues that, you know, at least are effective for us to talk about when we're talking about judges or talking to judges, and we think they translate into points you can make in your legislative advocacy during the next session. Second, we'll talk about, you know, really just advocating for yourself and some of the criminal justice related issues, stops, searches, seizures, those kind of things. And finally, just a few not legislative specific advocacy tips, but advocacy tips in general on how to get your points across when you're talking to staffers or legislators, or if you're speaking at a podium. So the first thing, you know, one of the things that, as Jamie or Kristin will tell you, when you're a criminal defense lawyer, oftentimes you are not relegated to practice in a specific county, right? We oftentimes kind of travel the circuit, going from county to county, and representing clients with similar charges, just in different courthouses. And in the last handful of years, what has become extremely apparent, and probably apparent to some of you listeners, is the differential treatment in possession laws and marijuana laws as we go from county to county, and sometimes even city to city. Functionally in Travis County, we have decriminalized small amounts of marijuana possession. Even before that, possession of marijuana in Travis County was worth a cheap class to get a pretty quick and easy dismissal that you could expunge, that you could erase from your record. And it was really no big deal. But as we travel down I-35, just in the county just south of us in Hayes County, the result is strikingly different. A typical result in Hayes County is oftentimes a deferred adjudication, meaning, you know, some kind of functional equivalent of probation and really a functional equivalent of guilt. Not the same easy dismissal that happens in Harris County. Williamson County, same thing. It's a probation case. It's something where there will be some kind of punishment imposed on the exact same thing that gets passed off in Travis County. If you travel up 35 to McLennan County, you know, you're facing jail time, you're facing surely probation. A dismissal result is really an aberration in McLennan County and places like Gillespie County, where you really need some serious luck on your side. So, you know, the differential treatment is one of the things that we always are concerned about. Our, you know, antennas go up, our constitutional antennas go up is when there are functionally equal protection issues where folks are treated differently for no other reason besides, you know, location. And so oftentimes when we're arguing things to prosecutors and judges about these kind of things, it's an important little flag to note, because I think other folks' antennas go up as well. Kristin?
Yes. So in terms of why we have such disparate prosecutions and some areas of Texas are functionally decriminalized, and other areas you're looking at jail time, is because in 2018, the Texas legislature, I'm sure you all are familiar with the hemp bill that went into effect in 2019. And so where that leaves us in terms of prosecutions in Texas is because hemp that's under 0.03% THC is now legal in Texas. When that bill was passed, local jurisdictions were having trouble getting DPS labs to test their marijuana to make sure that it was above the 0.03 threshold. And so that's what ended up, DPS said that we don't have the resources to do these tests. And so local jurisdictions, essentially a lot of the bigger jurisdictions, it started with Travis and then it went to Bexar County, and a lot of these bigger jurisdictions pretty much said they had to stop prosecuting misdemeanor level marijuana cases. And so the problem being, and this is why I think that this legislative session is going to be particularly ripe and ready to have some changes, is because it is completely, like we're said, to have this kind of disparate treatment, just depending on where you happen to get pulled over in the state of Texas, is not only potentially a selective prosecution issue, but raises all types of constitutional concerns. And it's just bad public policy to have your basic, your liberty and your freedom dependent on where you happen to get pulled over in Texas. So we're going to talk about that in a little bit. We think that this because this is happening in Texas, legislators know this, and we think they're going to be particularly receptive to trying to standardize this across the state.
And, one of the things that's so striking to us is as we're practicing throughout the state, and as, we hear stories of our other kind of colleagues who practice in not in the Central Texas area, you really see oftentimes marijuana and other drugs prosecuted to the same extent and the same level of, really violent felonies in terms of punishment ranges and things like that prosecuted in Travis County. It's not uncommon where, the same result that we get in a shooting case in Travis County is an equal result to some, smaller county like in Smith County, where they prosecute drugs pretty heavily. So, one of the things we'll talk about in our advocacy tips later, highlighting these kind of stories where the result is just so striking and shocking, 7 years for a shooting, 7 years for some kind of drug crime, I think has that staying power in terms of legislators' minds and these kind of stories when they're thinking about voting on a bill. One of the things that we are beginning to litigate more frequently in the last couple of years is the idea of how legalization in other states affects Texans' rights or travelers' rights when they're when they're caught in Texas with pot, or when they're pulled over and their car is searched because of the smell of pot. And the way we talk about it in our office and to judges and the prosecutors is how the Constitution's full faith and credit clause affects Texas's treatments of other states' marijuana laws. And so, as you all know, one of the main ways where criminal prosecutions are started is because of a car stop, and I'd say pretty easily 95% of especially any of the possession type cases, firearms, drugs, marijuana, they all start with car stops. I mean, over 95%. And generally they are started because or the genesis of a search is the odor of marijuana. And we have had multiple cases where clients who had either were traveling through Texas and were coming from a state where marijuana was legal, where they worked on legal farms in California and Oregon, and their car just had the odor of marijuana, where they get pulled over in Texas and ultimately get prosecuted for marijuana crimes or for some other thing that they had in their car that they weren't supposed to. And it creates this issue where we are functionally a traveler, a vacationer can go to Colorado and legally partake and smoke recreational marijuana, and perhaps their car contains the odor. And when they get to Texas, all of a sudden it's justifiable for a cop to infringe on their, personal rights and their liberty, and all of a sudden it turns into a marijuana prosecution or some other type of prosecution. And so, one of the things that we all try to find is some kind of legal justification for saying this is wrong, because it just seems wrong. And so hopefully we can try to convince a judge or a legislator as to why it seems to run afoul of the Constitution. And one of the things, one of the good kind of metaphors that I've read in the law recently was in 2017. We had an administrative law decision about the education agency trying to revoke a teacher's teaching license when he or she, I can't remember who, had failed a drug test. And the facts were that the teacher was in a legal state, smoking legal marijuana, and that was the genesis of the UA failure. And the administrative law judge said, hey, we don't take teachers' license away when they go and gamble in Las Vegas. And so the same thing should be true for marijuana when somebody legally partakes in a different state. And so we try to move that the same reasoning to these stops, especially when somebody's coming from a state with legal marijuana and when they have some kind of legal right to have that card, and to think, okay, if they're coming from a place where marijuana is legal and the smell that is supposedly the functional basis for the search potentially could come from some legal form in a different state, how is the Constitution allow a police officer to infringe on that person's liberty when they were just exercising their legal rights in a different state? And so it becomes this issue when we're talking to legislators and we're talking about trying to move the ball on that front. I think about the kind of the idea of a green buck from the Jim Crow era, when folks were really planning travels around places that were friendly. And it seems that the more and more, and as any criminal defense lawyer in the Northwest part of the state can tell you, the possession of marijuana business is booming. And soon enough, I would imagine as we have these green roads around our state, it surely is going to start affecting travel within our state. And so the more we can kind of focus on, the aversion to Texas as we have green roads around, and how that, can potentially affect, travel within the state, those kind of things, I think it's an effective talking point.
So I'm going to talk a little bit about self-advocacy and what you can do if you're stopped, or in terms of searches and seizures, and what to do and how to best protect your rights in those situations. So the first way that you're going to have, somebody's going to have an encounter with law enforcement is, as Worth said, most of our drug cases, not all, but most of them do come from vehicle stops. And so we always get a lot of questions about what are my rights if I'm pulled over in a car, and what can happen if I have marijuana in the car, or if I've smoked it at some point before. As we all know, marijuana can stay in your system for 30 days. So how can that impact, and what do I do to protect my rights? So in terms of being pulled over, some of the things that can happen is the DWI slide is the next one, Worth? Or is it I'm sorry. So the ways that the DWI, so here's what we have found in Texas in terms of, it used to be you would get pulled over, they would request a breath sample, you could decline or you could agree, and if you didn't agree, they would just arrest you. But now what we're seeing, because in part a lot of the DWI cases are now drug related and not alcohol related, or a combination of the two, what we're seeing in these cases is that we're doing a lot of the mandatory blood draws. And so what you can do in terms of advocating for yourself, because again, in a lot of the other states, they've actually gone to the legislature, that states that have legalized marijuana have come up with systems on what levels of marijuana. Like for example, in Texas, it's if your BAC is 0.08 or above, you can they can charge you with a DWI for 0.08 or above for alcohol related stops. But in terms of marijuana, we don't have a similar way to address the levels. And so what you can do in terms of just making sure you're properly protected, what we always tell all of our clients in terms of if you are pulled over, and if you look at law enforcement that gets pulled over, or a lot of the politicians get pulled over, and I'm sure obviously Jamie's the pro on this, but we advise all of our clients to invoke your right to counsel, not agree to do any testing, whether that be the standardized field sobriety testing or any type of breath or blood testing. And then of course, if the officers, if they believe, so the issues with marijuana driving versus alcohol driving, so there's typically not going to be a specific test that they can give you that will test other than a blood test. There are something called DREs, which are drug recognition experts that they will try to bring either on scene or after you're already arrested there at the station to do certain tests. But we always tell our clients, and in terms of invoking your right to counsel, requesting a lawyer, not agreeing. So sometimes if they do a mandatory blood test, but if they've lacked the probable cause on these marijuana cases, if you don't have marijuana in your vehicle, or if you don't have an odor of marijuana, we can then go and challenge the warrant for that blood. But in terms of the other issue that Worth and I, that is also going to be coming down the pikes in terms of litigation, is because of the Farm Bill and because of the fact that in the marijuana testing, because the basis for not prosecuting marijuana cases is because they can't adequately test to determine if it's a 0.03 above a 0.03 for the Farm Bill. And so we believe that there's an equivalent argument to be making in terms of odor of marijuana alone should not be considered, because odor of a CBD joint, for example, could be equivalent to a marijuana. And so that in and of itself, because is legal in Texas, should not be the basis for probable cause, and should not be the basis in terms of finding somebody guilty of a DWI that involves marijuana. So those are things that haven't necessarily been tested in the court, but we are eyeing litigation down the road on that issue. So that's kind of the first way that people, in terms of encountering law enforcement. And the second way that we see this happening is what we call street encounters. So if you're and knock and talk. So we'll go through street encounters first. So if you're walking down the street and an officer approaches you and asks to talk to you, you are absolutely free to go on your way. You do not have to stop and engage with the police officer. If they have reasonable suspicion to believe that you've engaged in crime or probable cause, they can arrest you for probable cause, or if they have reasonable suspicion, they can do what's called an investigatory detention. But the best thing to do, again, in terms of advocating for yourself, is just say, officer, am I free to walk away or free to leave? And if he says yes, then just go about your business. They don't get to just come and search you. Again, I think that would also get back to, even with an odor of marijuana, which is typically probable cause to do a search, because of the Farm Bill, we do think that we're going to have to start litigating, and we do believe that there should be additional protections, and that odor of marijuana alone should not be sufficient. And then in terms of the third way that you can have an encounter is with somebody, a police officer, just coming to your home and doing what we call a knock and talk, walking up to somebody's house or apartment or motel room or whatnot, and asking to talk with the person, asking them to step outside. Again, you're never under any obligation to talk to police officers or the only information that you ever have to give is if you are lawfully detained, you're required to give your name and your address and your date of birth, and that is it. So again, what I always tell my clients in terms of just advocating for yourself, if you are put in an encounter like this, a street encounter, a knock and talk, or a roadside stop, is just to ask for a lawyer and make it be unequivocal. So not, should I talk to a lawyer? Maybe I'm thinking, just say, I would like to talk with a lawyer before I give any information. And again, you're under no obligation to exit your home unless there's an arrest warrant. You're under no obligation to allow law enforcement into your home unless they have a search warrant. So, we do, in terms of advocating for yourself, and because marijuana is still illegal in Texas, we think the best thing that people can do is to make sure that their constitutional rights are protected. As long as marijuana is not legal in Texas, we all need to advocate for ourselves and invoke our constitutional rights at every step of the way. The other issue that we see a lot is the interplay between the Fifth and Sixth Amendment. And so what we'll see is when I'm telling you to invoke your right to a lawyer and to not incriminate yourself, that's the Fifth Amendment, and that's what we're dealing with. And again, to just use your constitutional protection, use your Fifth Amendment anytime that there is an issue with law enforcement. And then the Sixth Amendment is a little bit different. That only applies when you are undergoing custodial interrogation. So it requires both that you be in custody, and it also requires that they be interrogating you. And only when those two issues are present do they have to then what we call Mirandize you, read you your Miranda rights. So the reason that's important is because a lot of these encounters that we're talking about, where an officer, there's an encounter in a roadside detention or at a home or on the street, you're not going to be considered in custody. So the officers are not going to tell you that you have a right to have an attorney present. You just have to be able to do that on your own. And it's especially important because there's kind of an unequal playing field. The officers are allowed to lie, use trickery, deceit to try to gain your cooperation and any types of confessions, or a lot of times we'll see situations where officers will say, hey, if you just cooperate with me, it'll be easier. Don't worry. I'm just, and again, they don't have to be being truthful when they tell you that. So as long as marijuana is illegal, we all need to make sure we know our constitutional rights and adequately invoke them. Because as we talked about earlier, it really, if you're in Colorado and you're coming through back down, and we have seen so many cases. I think they just must patrol. Now it's going to be Oklahoma and all the other bordering states, but they patrol those highways from Colorado south back into Texas, knowing that a high percentage of vehicles that they stop leaving Colorado are going to have some type of edibles or marijuana in them. And that's where I also want to talk about the difference between flower versus extract. So because there are so many states that have legalized marijuana, and because there are so many different types of marijuana now in terms of edibles and gummies, and they're so ubiquitous that people kind of think, oh, it's no big deal. It's just a gummy, or it's just, a bottle of, whatever. But the problem and the way the laws have not really kept up with the reality. And so the reality is in Texas, if you have under 4 ounces of marijuana, leaf marijuana, so flower marijuana, it's a misdemeanor. But that is not the case with any type of edible or vape or any kind of extract. Any amount is a felony. And so it's very, we see this all the time where somebody will just have a vape pen, for example, and they cannot believe it's actually a felony offense to have even one gummy. So a couple gummies in your pocket or a vape pen, in your purse, that's a felony offense. And so it's extra important. And we are always trying to tell and educate people about this because, again, there's such a mixed message in our country now with the legalization. As you saw, we're in a sea of green, and Texas is one of the only holdouts. And it's really important. Some of the other issues that we see a lot are as it relates to encounters with law enforcement. Sometimes what can happen is that, for example, I had a client a year ago. She was on the Comal River with some friends, and she saw law enforcement approaching, and she had a vape pen on her inner tube, and she threw it in the water. And they saw her throw it, and they got scuba gear on and dove to the bottom of the river, confiscated it. And not only did they charge her with the actual vape pen. So again, a felony offense because it had THC oil, but they also charged her with tampering with evidence. And so this is where we see a lot of clients have trouble with. You actually end up eating gummies, throwing your vape pen, doing something like that, and you're actually in more trouble than you had been. Tampering with evidence is a 3rd-degree felony. It's very serious. And so again, what we advocate is invoking your constitutional rights. Don't do anything that could make it worse in terms of trying to eat gummies or throw vape pens or anything like that. But again, self-advocacy is one of the most important, I think, again, until we can convince legislators to do the right thing. So in terms, right, so that's what we talked about, the
So
farm
we
bill.
talked a little bit about the farm bill already. I think you touched on that, Kristin, but it really has had pretty substantial effects on, our job in terms of ways to attack probable cause for a search more than anything, and just hamstringing the prosecution's ability to make their case with the current testing capabilities through DPS. And so it really, functionally has been a game changer in terms of easing the burden of some of these pot laws. But I think we've already touched on it, so just head on. As we're getting ready for the legislative session, and y'all are going to be advocating and pushing forward the bills that you hope to get passed. I think it's important to touch a little bit on just advocacy tips when pushing for legislative change. And really the first thing is when we see our lobbying efforts successul, especially at the beginning stages, oftentimes what you'll be doing is not speaking at the podium testifying on a bill, but what you're going to be doing is talking to legislators, staffers. And legislators, staffers oftentimes don't have much access to the actual elected official. They're not going to really tell them any of the really good and smart things that you're likely going to tell the staffers. And so a lot of times effort is I think wasted on trying to convince the staffer to then convince the legislature. What's effective is numbers, plain and simple. Getting a lot of people to call, say, I'm in support or I'm against, and just repeating that ad infinitum as many times as you can, because that's what really persuades a legislator when getting information from their staffers. And so when we're talking about just lobbying at a base level, lobbying at the beginning stages before we're actually testifying in front of the bill, we really need numbers. And the scripts are easy. I'm so-and-so in this district and I'm in support of this bill. Hang up the phone. And just getting the calls out, getting as many folks to call, because that's what moves the ball at that stage. Once we're actually testifying in front of the Criminal Jurisprudence Committee or some other committee, I think it's important because our advocacy becomes a little bit different. You have, 3 minutes, I think, to get your point across. And a lot of folks are going to be, testifying in support and in opposition to the bill. And so if in terms of a coalition, what becomes unproductive is when the same folks, different folks on the same side get up and say the same things. Because the 3 minutes go quick. We don't want to just retread old ground. Everybody gets bored. The sessions are long. What is helpful is at the planning stage to ensure that everybody is A, finely tuned in what they're going to say, but B, make sure that everybody covers different ground. Because I can tell you, folks go to sleep up in those committees, and so it's important to cover new stuff. It's also, one of the things that we always talk about in advocacy is the two things that stick in folks' mind, and this is true if we're talking to a jury, this is true if you're talking to a legislator, is stories, statistics, right? simple statistics, simple stories, because those are the only real things that kind of have staying powers in our mind. And so the more that you can tie whatever your advocacy position is to a single story, hopefully less than 3 minutes, it's oftentimes more persuasive than the general kind of legal talk that we give. And more than anything, I think it's important in advocacy on any level is to find a villain. I've thought a lot about this. Who's the villain in our current prosecution of marijuana laws? And surely, cops, they're opposed to y'all's bills. Prosecution opposed to y'all's bills, but really, the folks that are making the most money off of this prosecution scheme is really criminal defense lawyers, right? I mean, it's more than anything, possession of marijuana laws benefit us, and nobody likes us. And so please, use us as a villain, right? We're the folks that are getting rich and able to buy big fancy billboards off of the kind of continuation and perpetuation of these laws. And so the more that you can name a villain that everybody already has a bad taste in their mouth about, I think it's helpful. I'm happy to take other villains, but those are the only ones that I'll say.
Yeah, and I think, it's important to note our landscape, our political landscape in the Texas House. So it's, obviously Republican, but a huge libertarian streak. So the more you can, this is really a libertarian issue. So it's not only a libertarian issue, but also a fiscal issue. Those are the two major ways that you can get support in the Texas Capitol. And so, a lot, when I started doing legislative work, 15 years ago or so, there would always be the marijuana bills filed, and they were just, they hardly had any bipartisan support. They were filed by, the most left progressive Democrat, and they got nowhere. And then every session, it's just gotten more and more and more bipartisan, more and more and more support. And so it's true. Nobody else, there's no, Republicans support, decriminalization, Democrats, libertarians. It really has become a bipartisan issue. And there are a lot of great other policy, Texas Public Policy Foundation, they have a great platform on criminal justice. And, so in terms of the more you can make this a bipartisan issue, a libertarian issue, the more success you will have at the Capitol. Jamie, you want to save a little bit of time for questions? I see we have some questions coming in.
Yes, let's do that.
I have a bunch on Facebook too.
I see the Facebook ones too, Jack. So let me go through some of these for now and toss some out. Let's see here.
I think we should start with what if the law enforcement officer will not answer if you are detained or not?
Did y'all hear that? What should you do if you're saying, officer, am I being detained? Officer, may I leave? And he refuses to answer that question.
What I would advise is I would say, because you haven't told me that I'm being detained, I am going to walk away. Worth, what about you?
Yeah, you'll find out real quick if you're detained or not at that point.
Right.
And most likely you are being detained, but I think Kristin's advice is right on that.
And you always have to keep in mind that at least in most of the larger jurisdictions, officers are required to wear body cameras. And so any encounter you have, or if you're stopped on the road, their vehicle is going to have a camera and audio. So you have to always keep in mind that you're doing things to protect yourself. So you want to make a record that you're not resisting in any way, you're being respectful. You're not doing anything that would be considered to be obstructionist or anything like that. But know that you're being on tape. And if you keep a respectful tone, and if you, again, your rights, you're being respectful. Am I free to leave? If I'm not free, if I'm free to leave, I'm going to go. Thank you, officer. Goodbye. I think verbalizing it, not just assuming, but putting your words, making sure your words are being captured on video and audio if there were any issues that would occur after that. But right, I mean, if an officer just walks up to you and says, "Hey, can I talk to you for a second?" You're free to say, "No, thank you, sir. I have something else to do. Goodbye."
There's a couple questions having to do with hemp stuff too that kind of all interlock with each other that we could chat about for a second as well. So someone brings up the hemp injunction. So as you guys probably know, there was a lawsuit about smokable hemp products, and currently there's an injunction until February where smokable and vapable products will still be available. So they're asking, what if the gummies that you're caught with are actually hemp?
Great
So-
question. Yeah. Go ahead, Jamie.
Yeah, sure. I mean, that is a great question. The answer comes down to, in theory, what the THC concentration would be, just because something, sorry, let me kind of back up. And I'm going to try to toss this in with some other questions as well. Another thing that I've seen asked, I think both on Facebook and in the Zoom app, deals with what happens about if we are able to take it off the federal schedules, if it's federally legalized and those sorts of things. I can tell sort of by the basis of the questions themselves, and this is a really sort of common misunderstanding. There's an English language issue going on here. When we talk about legalizing marijuana on the federal level, there is a legal theory about dual sovereignty, and the short version there is that both the federal government and the state of Texas are your kings and queens, and they both get to make rules that you have to follow whether you like them or not. So while, the answer is there that it needs to be done in both places, right? And this is sort of similar. The reason it ties into the hemp thing is because the federal hemp bill is where this started with the 0.3% THC. As criminal defense lawyers, the three of us don't have to go into court and prove that the cannabis that was consumed is less than the 0.3 THC percentage. In theory, the state has to prove that. Now, why do I say in theory? Well, in part, I don't know of a jury trial where this has been litigated. It has been something that, as Kristin and Worth already talked about in Travis County, we can use it for, really outright dismissals on even high THC cases that are felonies and things like that. And in other places that are harsher, it's something that potentially we can use to get a less harsh sentence than maybe our client would have otherwise. But yeah, those two issues are, it's still up in the air. The truth is this. It's really good that the hemp bill, really it was by accident that it caused this Texas state level criminal justice disruption in the ability of prosecutors to prosecute our clients for marijuana possession. It was just a gift, but we need to focus on getting rid of the whole shebang, no matter what the percentage is. Austin Criminal Defense Lawyers Association less than a month ago had a scientist on from Texas A&M talking about this, Nobel Prize winning new type of chemistry tests that they can do on certain substances to, yes, eventually figure out what the percentages of THC is in a particular cannabis plant, a hemp product, a CBD product, all of those sorts of things. So yes, we are continuing to waste immeasurable amounts of money on trying to figure this stuff out. I don't know if the two of y'all have any more thoughts on that after my rambling answer.
Right. It's assuming, so in terms of the testing, Jamie's right. It's the prosecutor's burden to prove that it's above the 0.3 threshold. And so what that looks like is having to send the gummies off to get analyzed by a lab. And, DPS has said, we are not going to test these, I think in terms of gummies and some of the oil, they do. I think they're more focused on turning away misdemeanor cases at this point, but it's still a huge burden on the system. DPS labs are backed up months and months and months. it's, for every, and I think that's a good point. A lot of times prosecutors will just offer your client a deal so that you don't have to do it. But if if everybody that's got busted with gummies would start demanding that the gummies be tested, and, you don't necessarily know, how are you supposed to know what percentage THC it is? I think the whole system would collapse. I mean, there's just no way they would have the capabilities to test all that.
Yeah, there's only 12 labs that are accredited to do that type of testing, and so in some cases, I think more rural areas have been like having to send it out of state to federally accredited locations.
Yeah, and so that might be a good legislative angle, is like, let's take the burden off of law enforcement having to waste their time on this. Let's divert their resources to something more important, so that might be a good angle as well, this legislative session.
And I want to jump in and add on something to what Kristin was saying in terms of using the criminal defense lawyer's greatest tool for your benefit, and that is setting a case for jury trial. Now, sometimes it's actually going to jury trial, and sometimes it's just setting it for jury trial. And sometimes you and your client know, are we 10 or 50 or 90% bluffing here when we do this? But here's the deal. When I first started practicing in the mid to late 90s, I kind of thought, I was lucky enough to practice in Travis County, and so dismissals were still a thing there. My client had to jump through a whole bunch of hoops, but I kind of viewed it as the state doing my client a favor, because I would also practice in Williamson County and Hayes and these other places where prosecutorial discretion was not used in that manner. Well, what I've come to learn over the years and decades of doing this is, in many ways, by having my client go take a silly 15-hour drug class and do some community service, that's good. That's a good thing for the community. That's fine. By having my client do that so that he's giving them a reason to dismiss it, we're doing them a favor, because the truth is they don't want to spend resources on these, certainly not in the big cities. So just kind of echoing what Kristin is saying there about, finding lawyers that are willing to push these things. Because if you ever actually go to jury trial on a misdemeanor possession of marijuana case, as a criminal defense lawyer, we're really used to talking to jurors that are they start off unhappy with our clients before they've even heard any evidence whatsoever. Just whatever charge is read, they think that's a bad thing, and our client probably did it. Well, it's completely it's really the total opposite of that when you're trying a possession of marijuana case. The hardest thing for the state is to get enough jurors that don't think that don't say they think the law is wrong and they won't follow it because it ought to be legal. But anyway, just adding that. I see as well, here is a question that I wanted to talk about. I have a charge for less than 1/4 gram of marijuana back in 1984 possession. If decriminalization were to go into effect in Texas, could that be erased? So this is one of my pet projects. Let's start with the important part first. We're going to have to completely legalize marijuana in Texas before we can go back and reasonably argue that we can get rid of those. But there are many states actually there are 17 states that have gone through some form of an expunction process or put processes in place for people to go back and do that. And there are actually several different ways of doing it. Sometimes it's extremely specific, like the state says, okay, if you were convicted of this specific statute, number 123.456 subsection A, and that might mean just, possession of a very small amount, and they're allowing expunction of that. Some states have made laws that basically say, you can expunge anything now that we have decriminalized later. And so it's much more open. In Illinois, I would love for this to be the case at some point in Texas. In Illinois, the governor there pardoned thousands, maybe over 10,000 people, I think, if I remember correctly, of various marijuana crimes. For example, in Texas, if that were to happen, if and when, find some wood and knock on it, but that it is doable after a few more years, potentially. It's, if there were a blanket pardon, for example, that would automatically make people eligible to expunge the old convictions under our current expunction laws. So there's potentially several ways of going about doing that. But like I say, we can't get taken seriously on that until we finish up with step one, which is let's make it all legal to start off with. Jax, did you see other
I have
questions?
a couple more so I kind of was writing down as people were asking while y'all were talking, which by the way, I thought the slideshow looked really great. So I like the graphics there, just random thought. So Stephen wants to know, if asked, do you hand over the stuff to the officer, or do we just not say anything and make them find it themselves?
Worth, you want to take that one?
Yeah. I mean, so this is the dilemma, because there are places where cooperation, you get some kind of benefit either at the cop stage or at the prosecution stage, but it's hard to weigh that on the front end, and because anytime anytime there is either an admission or consent or any of those things, it completely hamstrings our ability to contest, or not completely, but oftentimes hamstrings our ability to contest any other kind of legitimate search issues or legitimate seizure issues or anything like that. That it becomes, it's this calculus it's a really hard math problem to have, because you don't know all the variables. And so I always, advise our clients to, ask for a lawyer. And the more you can ask for a lawyer, the things that rather than, admit to anything, consent to anything, I want to talk to a lawyer. I want to talk to a lawyer. I've never been in this situation before. I want to talk to a lawyer. Because, as soon as we start admitting, consenting these kind of things, your constitutional rights that you can otherwise assert becomes, harder to assert.
Yeah, I think that.
Oh, I'm sorry, go ahead.
Sorry, just a quick follow-up on that. I love that answer, because so often the answer you get from a lawyer is just absolutely say nothing, do nothing. It is absolutely more complex than that. In this particular situation, for example, it is sort of something that you would need specialized knowledge in. Now, I don't mean specialized knowledge because I went to a fancy law school, la-di-da, and read a bunch of law books. I mean, I happen to know in Travis County what the rules are. So, and this really would apply, since we've effectively decriminalized it completely here, to a couple of years ago. If it was 2, 3, 4, 5, 6 years ago, and an Austin Police Department officer was saying to me, and by the way, this is something that could happen to other people in other counties in the future before it's completely decriminalized, even if this isn't something that's there now. If you know that they have a program where they're just going to make you go get a class and get it dismissed, if for some reason you already know that about the county that you're in, which you might, these things are knowable. And if the officer is saying, hey, I smell it, I'm going to search it, you can make it easy. If you make it easy for me, I'm going to write you a ticket. You're going to go home tonight. If you make me work and find it, I'll be here. I'll find it, but you're going to jail. In that, and if it was going to be found in a place where it was my car and it was going to be pretty obvious, or I happen to know it was in my pocket or whatever, it was going to be pinned on me anyway, and they were going to find it. To me, that's a real clear example of what I would call a win-tie situation. You either win by giving them the dope and not going to jail that night, or you tie because you were going to jail either way. I mean, there's no downside there, right? But you don't always have that specialized knowledge. It's not dissimilar to the question that criminal defense lawyers get about field sobriety tests. A lot of times lawyers will say, never do the field sobriety tests. Well, the real answer is you should do them if you're going to look pretty good on them, and you shouldn't if you're not going to look good on them. But you don't really have, that is called incomplete information. And I don't mean because you're intoxicated. I mean, you just don't know, So yeah, I think that was a great answer, even though it falls in the it depends.
Yeah, I was going to say, too long didn't read version is depends.
But you might know that. And it's worth knowing in your, listen, if you're going to be speeding, you should probably know that the maximum you can get is a $200 spanking on a speeding ticket, right? If you're going to engage in certain types of risky behaviors, it's probably good to know what the range of potential consequences are. And listen, if you live in a place where those spankings seem extra high, then maybe your answers to those questions will be different. And hopefully you have some sort of an idea. If you're just randomly driving through Texas, I would go with if I ain't near the big city, probably the more I need to keep my mouth shut.
Yeah, I'll only break
Jamie,
one law at a time, right?
Yeah, and Jamie, you brought up a good point, and Kristin touched on this earlier, and I think it bears repeating. With the advent of body cams, and even before so with just the dash cams, but now that really everything is going to be recorded most likely, your interactions with police are performative more than anything, in terms of how we invoke, how we treat the cops, how we talk to them, because ultimately that picture, that camera is going that video is going to be shown surely to the prosecutors, maybe to a jury. And it's oftentimes my clients who know their rights really well like to confront the police officers with their knowledge, which is oftentimes more than the police officer's knowledge of the law. And it doesn't always read well. I take that. It rarely reads well to a prosecutor. And so when I say they're performative, Kristin, mentioned multiple times about being nice, being courteous, those kind of things. It's very, very helpful in terms of looking forward into the future on how your case is going to get resolved. Because oftentimes, regardless of what you say about your rights and regardless of what you say about wanting a lawyer, it will ultimately result in some kind of criminal case, and so especially in some of the little smaller counties. And so when we talk about, invoking your rights, surely, nice, respectful, all those kind of things help you on down the road more so than some of the other ways to invoke.
So there's a couple quick, easy answering questions that I'm just going to bam, knock out real quick. And then we've got a more detailed one about pregnancy and then also about voting rights. So first of all, someone was asking, when will the MORE Act be up for a vote? And it's been promised that it would be once they return from the holiday break, but I, wouldn't bet the house on that, because I assume that they'll be talking about, the COVID funding that they're looking at and all of these other issues that are happening. So it might be moved to be even later. And then also, someone was talking about ballot initiatives. There are organizations out there that are working to change the way that those ballot initiatives work in Texas. So if that's something that you want to work on changing, look them up, get coordinated with them. And then I've heard some people talking about Abbott and the lieutenant governor. So one said, it's not going to happen as long as Abbott's here. A few things of note: he did sign a medical bill, he did sign a hemp bill, and he negotiated with Moody for a decrim bill that, if the lieutenant governor wouldn't have stopped, would have passed. So he has come a ways on that, but if that is not enough for you, he is up for election in 2022. Same with lieutenant governor. We're going to be stuck with him through 2022. And so really, if religious leaders in the area, people who happen to be donors to him, having those type of people approaching him and having those conversations with him are going to be extremely important. And then also, how can I help is what some people have been asking. If you go to texasnormal.org, you can go to our activist training guide, click there, and that kind of gives you an update on all the things you need to know to get started. But I would also say sign up for our newsletter, because that's where we're going to be giving legislative updates. And then also you can become a member online if you would like. And then I think there was a question, when will medical marijuana bills be heard in Texas? So the way that it works is we now have, in many cases, the legislators that will be working up at the Capitol, they can start pre-filing bills as early as the 9th, which is next Monday. And then they come in for session on January 12th. At that point, they should be choosing their Speaker of the House. Then they coordinate their committee assignments. And then once those committees are assigned, the Speaker or the Lieutenant Governor will send the bills to where they go. And then the process will get started. So it won't be until earliest beginning of February next year. It could be end of February, beginning of March at the latest. I do also want to note that during this session, we're going to have to elect the Speaker of the House, deal with redistricting, deal with the COVID budget shortfall, And there's sunset commission items. Sunset is when an organization's timing out, if you will, and they have to renew everything. And that's going to be happening for the Texas Department of Agriculture. So there's a lot that's on the docket there. So then I think the last quick one that I can rattle off an answer to is when will we legalize medical marijuana at the federal level? So there's different ways that can happen by them removing it from the Controlled Substance Act and then allowing states to do as they wish. They can also reschedule it to a lower schedule so that more research and production can be done through pharmaceuticals. Many people prefer totally descheduling as opposed to rescheduling. Descheduling is more in line and more authentic with the fact that this is a plant, not a highly commodified chemical pharmaceutical. And so I rattled those off real quick, but just to let you guys know from the Facebook comments, there's a question about voting rights being restored in Texas.
I saw that.
Yeah, could you guys speak to that?
Sure. So depending on what mechanism was used to put a previously convicted marijuana defendant in a position to where they could get it expunged, you would expect that to then give them back their voting rights. And more specifically, of course, what I'm talking about is if there was some sort of a felony marijuana charge, you would not lose your voting rights in Texas for a misdemeanor conviction, but you could become a felon for marijuana or THC. I'm sure that any sort of that would get taken care of, whatever the mechanism was to remove the penalties of your conviction. So yeah, that would all be part and parcel of that.
My understanding is like you have to be off paper. So you have to be done with all of your parole. And then at that point, I think you fill out a form. I could be wrong. And then you get your voting rights restored. Is that kind of correct?
So if you're talking generically, I mean, the way I was reading the question, and actually let me just go back and say this, could expungement also include reinstatement of voting rights too? But yes, I mean, I guess my answer is that it's just unimaginable that there would be some form of expunging, erasing, whatever you wanted to call it, the conviction, without the reinstatement of any previous rights that you would have. For example, not just voting rights, but possession of a firearm by a felon. If you had a felony marijuana conviction from last year that suddenly it becomes legal, and then a few more legislative sessions, so 5, 6, 8, 10 years down the line, they expunge all of them. At that point, you would no longer be a felon, and you would not be under the restrictions of not being able to carry a firearm. Same thing in terms of voting rights is my generic answer to that.
Got it. All right. Well, I think there's one last question that we can touch on before we close for the evening. Matthew says, there seems to be a fundamental indifference on the state level for a mother's choice to ingest cannabis during pregnancy for her health benefits and reasons. What are we doing to address mother's rights on this issue?
So I personally wouldn't be able to say that I know really a ton about what the medical issues involved would be for something like that. There's not much question that the state has the power to regulate medical issues much more than some people would actually like in a variety of contexts that we won't go into here. So even if, I mean, for example, alcohol is a legal substance, but a mother could get in trouble for ingesting too much alcohol while pregnant. To pretend that there could be some sort of blanket rule that no matter what a person did what a pregnant woman was doing in terms of ingesting marijuana, that was absolutely legal no matter what. I can't imagine something like that passing, but it's also not something, I probably ought to go back to the first thing I said, which is I'm not an expert on the subject, and I don't know if Worth or Kristin has anything they'd want to add to that.
I mean, the only thing I would add that the only thing scarier than the criminal justice system is the CPS system. So
Yes.
and that's it, as far as my knowledge goes.
Yeah, that's a good point. I would say for now, let's not test that theory.
And, just in hypothetical world, right? If this is a patient registered in the Texas Compassionate Use Program whose doctor knows that she's pregnant and is advising her to continue using this medication, that's vastly different than a parent who is ingesting while pregnant from an illicit, non-prescribed market, right? And so being very thoughtful about that line, I think that's probably where it is right now. I know that in general, people are very controlling about women and what they put in their bodies while they're pregnant. People have strong feelings about coffee and wine and all this other things. So I think it would come down hypothetically to, are they a patient? Will their doctor attest to the fact that they did tell them to take it? All right, well, I think that that's everything for the questions. I'm glad that we went a little long so that, oh wait, actually, I'm sorry, one more on labs. Let's just knock this last one out. It's the very last one. Are labs still testing products, or are state labs on hold due to COVID? So I think COVID testing happens more in a medical lab, like the Austin Regional Clinic lab or something like that, whereas testing of cannabis would be in these ISO certified labs that are in Texas. Would that be correct?
Sounds right to me.
Okay, well, then we'll go with that. All right, Jamie. So that's all of our questions for tonight. You want to close it out for us?
Sure. I want to say thanks to Kristin and Worth for being here, and thanks to everybody for joining in. Angelica is the winner of the t-shirt. If you will get with us, I will make sure that gets the t-shirt giveaway for the questions asked. Make sure you get with us afterwards, and we will get that mailed out to you. Appreciate everyone being here, and thank you so much. We have our open meeting on the first Wednesday of every month. So please, do all the social media stuff, liking and subscribing and keeping in touch with us. And we'll keep on keeping in touch with you. Thank you, everyone, for being here. Thank you, Jax, as well, for running this. I appreciate it, everybody. Everyone have a good night.
Thank you. And Angelica, I just put my email address in the chat. Email me and I will get you your shirt. Thank you, Kristin. Thank you, Worth. Thank you, Jamie. Everybody have an awesome night.
Stay safe.